Next case set for argument this morning is is Ellis versus Fortner. Case number 28992. Both parties are represented by counsel. Each will have 15 minutes to present your arguments. The appellant may reserve up to 5 minutes for rebuttal. Please keep an eye on the clock on the screen. That'll tell you where you are as far as time remaining. We need to minimize that for the child. I believe there is a minor involved. We prefer that you use initials as opposed to names for minors. We've read the briefs and are ready to proceed if you are, so. Counsel.
Thank you. I'd like to reserve 5 minutes for rebuttal.
5 minutes, very good.
Thank you, Mr. Board. My name is Doug Leak, and I'm here on behalf of Dr. Fortner and our medical group, and at our table is trial counsel, Brad Longrick. And on behalf of Dr. Fortner, we ask that this court reverse the jury verdict that was tainted by multiple errors, both prior to trial and during trial. First, pre-trial. The trial court abandoned its duty as gatekeeper to exclude 2 causation theories that are not scientifically accepted in the medical field and in fact are rejected. After denying that, it goes to trial. That error is compounded in several different ways in terms of gutting our defense, denying us a level playing field, applying different rules, and simultaneously bolstering the plaintiff's case. We have presented 9 assignments of error, and we believe that 8 of them are prejudicial in and of themselves, warranting a new trial. But at the very least, the cumulative error doctrine applies because Dr. Fortner was denied a fair trial. I'd like to start with our first assignment of error regarding the plaintiff's theory referred to as CCIE, cranial compression ischemic encephalopathy. First of all, with regard to our Daubert motion, that motion was ruled upon without any hearing, despite our request, and the denial of our request to file a reply brief.
Of course, there's no obligation of the court to have a hearing on a Daubert motion.
It's not mandatory, but the law does say to come forward with enough evidence to warrant that hearing so the trial court judge can weigh the credibility of these witnesses, see these witnesses, weigh the evidence. It is necessary. And in this case, we came forward with ample evidence. And it's interesting, you have to look at the genesis of this theory of why the Daubert motion on its face should have been granted. CCIE is an alternative causation theory when the plaintiffs cannot prove the recognized condition of hypoxic ischemic encephalopathy. And in this case, the child could not meet the criteria for what's called HIE through the pH levels of the blood and other criteria. So what happens across the country, and in particular this case, is the plaintiffs, when they can't prove HIE, have to go to this alternative causation theory called CCIE. And in doing so, in this case, just like many other cases across the country, they retained 2 experts, retired Dr. Barry Schifrin and also Dr. Stephen Glass.
Counsel, let me ask you, I read your brief, obviously, and I go read the other side, and obviously if everybody agreed, we wouldn't have jobs, but that's a different issue. They say that they did not present CCIE, that wasn't their theory of the case at all. How do you address that?
Well, they try to use the word brain trauma, but in actuality, it's CCIE, okay? So our position is that they're playing with the word brain trauma, but technically, it is the CCIE theory. So that's what is at issue. So what we're claiming is that before trial, that's what they were pursuing, was the CCIE theory on causation, and that's why we filed the Daubert motion. And in this case, neither Dr. Schifrin nor Dr. Glass could satisfy Evidence Rule 702 or the 4 elements of Daubert. And in fact, we came forward with ample evidence, both evidence and testimony, that this theory is not generally accepted by the medical community and in fact has been rejected. With regard to the 4 elements, there's no doubt and no question that the CCIE has never been tested. Dr. Schifrin and Dr. Glass admitted to that. Our experts, Dr. Michael Epstein and Dr. Michael Belfort also echoed that. The second element, there's no question that this has never been peer reviewed. Neither Dr. Schifrin nor Dr. Glass could point to any peer reviewed publication dealing with CCIE, and they admitted that there isn't. Also, their other expert, Dr. Jeffrey Pomerantz, admitted that there is no peer reviewed publications on CCIE. And our experts, Dr. Epstein and Dr. Belfort, also confirmed that. Then the third element, is there a rate of error, known potential? Even the trial court admitted that there isn't because there's been no testing. But the most important element here is that it is not generally accepted by the medical community. And we know that because, first of all, Dr. Schifrin's own publication states that CCIE challenges the prevailing monolithic Young view. So that's an admission. Then we have ACOG, who put together 16 physicians for a task force over 2 years doing research and investigation that flatly rejected CCIE. And then we had Dr. Pomerantz testify about his colleague's letter, Dr. Ader's letter to ACOG, requesting that it be recognized. That too was rejected. Our experts, Dr. Epstein and Dr. Belfort, also said, not accepted, rejected. We presented the affidavit of a nationally known expert, Dr. Volpe, who clarified that the plaintiffs were mischaracterizing his position, not accepted. We presented the publication of Kent Hayborn from 2017, just recently, rejecting CCIE. And then we have the publication of Dr. Roger Freeman, who said that this is nothing more than a legal theory with no basis in science or any basis for that. And how do we know? This should have been excluded before trial. But to bolster our argument, we have to go to the trial transcript. And I point you to pages 727 to pages 729, when Dr. Schifrin was on the stand and was asked the question, has CCIE ever been generally accepted in medicine? And he responded, no. He admitted that at trial. We moved to strike the CCIE theory at trial. It should have been stricken then, but more importantly, this confirms our whole position on CCIE before trial, and it should have been granted. We also presented several cases from around the country. The Smith versus Boswell case from Georgia, an appellate decision rejecting CCIE. We presented Trujillo, a case from Colorado, where they conducted a 5-day hearing, unlike here, no hearing, a 5-day hearing, and that court rejected CCIE and Dr. Schifrin. So I'm going to move on because I'm limited on time here. So in terms of CCIE, it should have been that. Then our next one, Daubert, ASD, autism spectrum disorder being caused by HIE. You have to look at the trial court order of January 2019. They relied upon Dr. Glass, who said that this child did not even have ASD. And then they used, the trial court used Dr. Wassertein, who is a PhD who can't even render an opinion on causation. So they can't even establish ASD with those two witnesses. We had Dr. Volkmar, the world-renowned expert on autism, that says there's no connection between ASD being caused by HIE. So that was all pre-trial. But moving to the trial, I want to touch on how then the trial court gutted our defense. With regard to CCIE, limited our cross-examination of Dr. Schifrin. We could not cross-examine him about the ACOG rejection, his censure by ACOG for giving improper opinions, Dr. Volpe's affidavit, or the other cases he was excluded. We couldn't do that. But at the same time, we put that in our assignment of error number 3. But look at our assignment of error number 5, dealing with our expert. Dr. J. Goldsmith could not testify about his own involvement in ACOG and the rejection by the task force of CCIE. And then Dr. Goldsmith could not talk about the U.S. Preventative Science Task Force system for evaluating cases scientifically. So Dr. Schifrin, we were limited to cross-examine him, and Dr. Goldsmith, we could not get into these subjects challenging CCIE. Then on ASD, they completely eliminated Dr. Volkmar, the expert on autism, our expert from Yale, on the basis that it was cumulative, but not. The trial court stated it was, cumulative because we should have asked the other experts, but the other experts, Dr. Epstein, talked about the child's condition and prognosis, and then we had Jerry Taylor, PhD, neuropsychologist, could not testify on causation. Dr. Volkmar was going to talk about the science of ASD and why it wasn't connected to HIE. But then you look at assignment of error number 6, their expert, Dr. Wassertein, a PhD, was allowed to offer approximate cause opinions, and we know that because plaintiffs at page 28 of their brief admit Dr. Wassertein offered expert opinions.
I'm going to stop you now only because we're at 5 minutes.
I'm going to go 2 minutes real quick. So then, assignment of error number 3, we also addressed the standard of care opinions that Dr. Schifrin was allowed to improperly apply. He was the approximate cause expert. He wasn't qualified to give standard of care under 601D, but he was allowed to give 6 standard of care opinions. And how do we know it? I want to look at the transcript from pages 540 to 637. There were discussions about these standard of care opinions. Page 546, the plaintiff's counsel had to be reined in because they were getting into standard of care. Page 552, plaintiff's counsel said he was laying groundwork, and the judge said groundwork is standard of care. At page 602, the trial court judge was asking, why isn't your standard of care expert testifying about these issues? Dr. Hamar, why isn't he doing it? The judge recognized Dr. Schifrin was offering standard of care opinions. Page 636 to 637 is very crucial here, where the trial court admitted that there was an overlap here. Schifrin was given standard of care opinions, that a jury could infer negligence, and then most importantly, it had to be cured, meaning error had to be cured, and suggested that trial counsel ask one question to cure that error. So not only do they have approximate cause expert Dr. Schifrin given standard of care opinions, then Dr. Hamar, as seen in assignment of error number 8, gave approximate cause opinions. And he was their standard of care. So the level of play here is unequal. And let me finish with, unbelievably, how we were denied the ability to cross-examine Dr. Schifrin, an expert on a crucial issue of the case, on credibility, bias, how he's been excluded before. We were not allowed to do it. But the plaintiffs were allowed to cross-examine a defendant, Dr. Fortner, about a business 6 years later, after the child was born. We submit to you that we have prejudicial error in and of themselves in our first assignment of error. But at the very least, the cumulative error doctrine that does apply in civil cases, as seen in Daniels versus Portosa anesthesia, applies. There's a pattern of error before trial, during trial, that denied the defendants a fair trial, and we ask that the judgment be reversed and a new trial be granted.
All right, that leaves you with 2 minutes and 28 seconds for rebuttal.
Thank you.
Thank you. Counsel, you'll have 15 minutes.
Good morning, Your Honors. My name is Paul Flowers. I represent the plaintiff appellees in this case, Gavin, Lisa, and Matthew Ellis. Joining me is my associate, Louis Grove. We also have David Skull in the background, who's one of the trial attorneys, and he's joined by Lisa Ellis. As fate would have it, today is GS's 18th birthday. This all relates back to what happened 18 years ago, and we really have no discussion about the actual liability phase of the trial. Given that, I thought I'd start off with Judge Callahan's questions, dealing with the first assignment of error, and whether or not there really was a debate over CCIE here, cranial compression, ischemic encephalopathy, and there was not. What counsel told you, and what they argued in their brief, is that plaintiffs could not prove HIE, hypoxic ischemic encephalopathy, a well-recognized condition. They say we couldn't prove that, so we jumped to CCIE as our kind of crazy theory to establish causation. And that's just simply inaccurate. HIE was diagnosed from the get-go by the treating physicians at their hospital. So Plaintiff's Exhibit 4 is portions of the medical chart. The very first page is the discharge summary, issued 2 weeks after GS was born. The diagnosis, final diagnosis, there's only two. 1, hypoxic ischemic encephalopathy. 2, neonatal seizures. And the physician who made this diagnosis, the treating physician at Altman Hospital, Dr. Brenda Douglas, she didn't just make that up on her own. If you go through the chart, it's replete with episodes of these conditions. So the day after GS was born, April 26th, we have a note, a doctor's note, term baby with HIE continuous seizures. We go a couple days after that, and it gets even more developed. Seizure activity, likely secondary HIE to difficult delivery. Not just HIE tied by this physician to the delivery itself, the difficult delivery. And that was just no mistake, because we have essentially the same thing repeated a couple days later by the physician. HIE, secondary.
Counsel, let me ask you a question.
Sure.
Difficult deliveries are difficult deliveries, which
Correct.
perhaps the females would know better than you, but given
Yeah,
that
very
as it is, how in your case did that become the doctor's doing?
Correct.
What portion of it?
No, that's a terrific question, because I'll be the first to say that just because there's a difficult delivery doesn't mean the doctor committed malpractice. In fact, probably the majority of difficult deliveries, there is no malpractice. So that's a critical element. That, goes back into the delivery itself, and where we're having no debate. They just don't want to talk about it. And that all ties together. So let me just back up. Actually, we had a 4-hour labor here. The baby was being pushed. This is a large baby. We had a malfit. He's positioned the wrong way. 4 hours of his head being banged against the mother's pelvis. 4 hours of that. That's followed then by a vacuum extractor that pops off 3 times, 2 to 3 times. 2 by Dr. Fortner's own acknowledgement, 3 according to the Ellis's. Takes a lot of force to do that. Then, while Lisa's being held on the bed, and Dr. Fortner has her foot up against the bed, she uses the forceps, the wrong forceps, to pull Gavin through the delivery. That is a difficult, forceful delivery. And there's no reason to get into CCIE, because everyone agrees that if you have a traumatic birth, you can have a brain injury. So that's the defendant's own physicians. So if you go to Dr. Landon, who's their OBGYN, he says forcing a vaginal delivery despite a poor fit can increase the risk for a traumatic birth injury. That's at the transcript, page 2614. And their neonatologist, Dr. Paul Kingma, he acknowledges that mechanical trauma to the fetal head can cause severe ischemic injuries.
So that, by mechanical trauma, we're talking the forceps of the vacuum.
Correct. Correct.
Is that the theory of the case, that the forceps of the vacuum caused the injury?
Correct. And it all goes back to
Let
that.
me turn around and ask you this.
Oh, sure.
If that's the theory of the case, why Dr. Schifrin as an expert?
Well, Dr. Schifrin's just there. Dr. Schifrin's just there to establish proximate cause. All right, so yes, he has done work with CCIE. He didn't need to get into that here, and he says that. He says, you're just using terms. He says, trauma has always been known in certain situations to cause brain damage. That's always been recognized, and everybody recognizes it. So it's the jury's job then at that point. The defense experts' knowledge it can happen. They're just saying it didn't happen here. They don't know when it happened, but it wasn't Dr. Fortner's fault. So it's up to the jury to decide which of the experts is more credible on that.
And can I ask you a question? I don't have the medical knowledge, but I'm trying to discern in my mind the damages to this child / now young man, because I don't necessarily equate autism with brain damage. Is there brain damage, or is he autistic?
Right, and it's an important question, but it's a distinction without a difference. First, you're right. That was one of the things I found interesting about the medical testimony was that the vast majority of autistic children and adults have perfectly normal brains. There's no brain damage. The GS here is undisputably brain damaged. I mean, on the studies, on the CT scans and the MRIs, his ventricles are abnormally large because the tissue around them has been destroyed. He has autistic-like symptoms. That's what everybody says. All right. Dr. Wasserstein, yes, she does at times characterize that as autism spectrum disorder. Dr. Armstrong, Dr. Glass do not. Dr. Glass says he doesn't think he has ASD, he doesn't want to call it that, but he's got a host of complications. And they all agree that the host of complications.
what you want to call them doesn't really matter. You got different experts saying different things, but that's for the jury to sort out, which is what they did here. The indisputable fact is that that step you recognized earlier, once you make that connection between the traumatic delivery and the brain damage being proximately caused by that, then it's all a matter of degree, which is something that will always lead to juries. So it really, Judge Oldfield did a terrific job in this trial. This is one of the cleanest transcripts I've seen for the 2-week trial of this magnitude. And she does, at the preliminary stage, it's just a motion in limine, it says that you're going to be able to bring in, these concepts, I'll review it at trial, it's a motion in limine, and then it never comes up. I mean, they've made their objections, but they're objecting to testimony dealing with trauma, not CCIE, and she recognizes that. So, circling all the way back, yes, the answer to your question was no, CCIE was never a factor here. And ASD, it's just a label. He's got severe cognitive deficits. What it's called doesn't really matter. And I would point out in Dr. Hull's notes, which I read, now this is the treating physician at Akron Children's, he says he's got ASD. This is when GS is 9 years old, well before the situation starts. So difference of opinion, what you want to call his conditions, makes no difference to the jury's award. I think I'll just touch upon the rest of the assignments of error. What time that I have left? My first time in this courtroom, getting used to
Got about 7 minutes left.
Okay, good. Just turning then to the third assignment of error, this is kind of a hodgepodge dealing with Dr. Shifflin and Dr. Volpe's affidavit and all that. And they're saying Dr. Shiffrin, who's supposed to be just a proximate cause expert, is allowed to testify on standard of care. And what they're arguing here is that he never criticizes Dr. Fortner, but you could infer that because he said that GS suffered brain damage during birth. And that's going to be true in any case where you have a damage witness. They're always going to say that the damage was sustained at the time that the defendant allegedly committed, the tort. You can infer that there's, a tortious wrongdoing there. That's just an argument can be made at any time. It makes no sense here. It never goes into whether or not Dr. Fortner should comply with the standard of care, and he stays well within his expertise without getting into CCIE. And they've thrown in here that they should have been allowed to use or introduce Dr. Volpe's affidavit, which is, not even arguably admissible. They're plainly trying to use that affidavit for the truth of the matter asserted, which is that Dr. Volpe doesn't agree with how his textbook's being interpreted. They could have called him as a witness, but they didn't. And allowing them to just read the affidavit to Dr. Shiffrin and ask him if he agreed with it, that would violate plaintiff's right to cross-examination of this piece of paper that they want to introduce as an expert. On assignment of error 4, the exclusion of cumulative testimony, this is where they're talking about Dr. Volkmer. And this is, something I've noticed throughout this, where's the proffer? They seem to think that if they say to the judge, Dr. Volkner went to Yale, he is awesome, he's going to blow their case away, that's their proffer. And that's not how it works. There has to be some testimony there. Deposition, stipulation, a report that's been introduced into evidence, something where we can see that, yes, this is what this guy's going to say. That's true for several of these. With Dr. Volkmer in particular, this was followed by a lengthy exchange with the judge. And at this point, this is where Judge Oldfield says, you can call 20 witnesses if you want. I don't care. They just can't be testifying about the same thing. And it's critical that we give trial judges that authority, that case management authority, because today it's very common for lawyers on both sides to just list a host of experts, and the other side can't figure out which ones they're going to call. You could put up the same experts say the same thing, or different experts say the same thing over and over, and you can have month-long trials. And that's why this is so highly discretionary. Just like the evidentiary rulings, these case management rulings are extremely discretionary and for good reason. And here, Judge Oldfield carefully goes through it, and what Dr. Volkmer is going to say is the same thing Dr. Taylor says. Now remember, in their brief they say she excluded him because Dr. Epstein was going to testify on the same subjects, and he testified on completely different things. No, she said Dr. Taylor had testified on these same subjects, and he had. He already covered the fact that in his position, that you can't get ASD from a brain injury. Already covered, already in there. No need to call Dr. Volkmer. Assignment grant number 5, the limitation on Dr. Goldsmith. They say he was excluded, he was not. Judge Oldfield did a compromise ruling. She said he could talk about the science behind his opinions, he just can't get into outside parameters. And what are these outside parameters? You know, there's no proffer there where he explains what outside parameters he would have gotten into if he had the chance. We don't know what they are. Assignment variant number 6 deals with Dr. Wasserstein, who I talked about briefly, and the complaint here is that she's just a neuropsychologist. She can't testify about proximate cause, and that's not the case. She comes in, and when she comes in, brain damage is already established. It's established in that note I read to you from the NICU and ICU. It's established with Dr. Douglas's discharge summary. It's been firmly established that on the CTs and the MRIs, GS has brain damage. She's testifying about the effects of that. You know, what does this mean? And that's what she gets into. To a normal person, to a lay person, he's going to appear to be autistic. And she does use ASD, autistic, ASD nomenclature. But it doesn't matter how you describe it. He's still got brain damage. He's still profoundly impaired. And the award damages that the jury came up with, which is not everything that the plaintiffs were asking for. The word they come up with is reasonable under those circumstances. Moving on, assignment variant number 7 is Dr. Fortner's consulting work. They're objecting to that. 6 questions, just very briefly getting into, I guess the idea was she's still working as an OB, 24 to 48 hours a week. How could she do that when she's also in this business? And I thought she had a very good explanation. She even said, I did the consulting work so I could spend more time with my family, so I thought it worked out very well for her, but certainly nothing that justifies a new trial. Assignment variant number 8 is Dr. Hamar. Dr. Hamar was the plaintiff's only standard care expert. They were only allowed one, and they only called one. And he supposedly gets into proximate cause. And again, it's another inference, you know, because he says that there's a standard care violation, that he's inferring that all this harm was caused by the doctor. Yeah, you can always make that argument. There's always going to be some overlap there. You know, it's kind of, it's odd here. I mean, I just don't get this. Counsel just gave you examples of that, you know, of how when plaintiff's counsel starts asking questions, the judge starts telling him that he needs to be reined in, that he's going too far. And that's true. Judge Oldfield was sustaining defense objections. You know, how is that reversible error? You know, they objected when the line was crossed, and the judge sustained those errors, you know, over and over and over again. Not errors, those objections. So you've got a judge who's very fair here, who's keeping both sides reined in their words, reined in. So that instead of having a month-long trial, we have a 2-week trial, which is exactly what you would expect for a medical malpractice case of this magnitude. Very well managed. Evidentiary rulings are well within their discretion. Nothing here that would warrant a second trial. Let me just wind up then with cumulative error. First of all, you know, we don't believe there's any prejudicial errors here at all. But the Supreme Court's rule, not the 8 districts rule, but this in Daniels, the Supreme Court's rule is that you only reverse for errors that are prejudicial and that part of the case only. And that's the Charles L. Combs trucking case. You don't reverse the whole thing just because you have some sort of error on damages. The other point to make here is that this court in McMichael's, this is the exact same panel we have today, just 2 years ago. In McMichael's, this court says this argument, cumulative error, has to be raised below. And they didn't raise it below. It could have been raised in a motion for a new trial, and they didn't do that. So it's been waived. In McMichael,
I have to interrupt you. You are out. You've used all of your time.
I was just finishing. Thank you.
And that leaves you with 2 minutes and 28 seconds for rebuttal.
Thank you. With regard to whether or not this is CCIE, the reason we filed the daughter motion was because their expert reports and the discovery depositions asserted CCIE. And then when we briefed it, they never came out and said, this isn't CCIE. They challenged us saying it's acceptable. So we know it's CCIE because they fought it. And that's how it was presented at trial. In terms of the HIE, there are references in medical records of HIE. However, in hindsight, with the benefit of experts reviewing the medical records, Dr. Schifrin, their expert, Dr. Glass, their expert, Dr. Pomerantz, their expert, all admit that this child did not meet the criteria for for HIE. HIE is a type of injury. It does not equate to a mechanical trauma. And what they had to do alternatively was use the CCIE theory. And that's why they got these experts to assert this, that it's not accepted in the medical field. In fact, it is rejected by ACOG and all the world-renowned experts. On ASD, there was a question regarding whether or not this could be caused by a mechanical injury or in that sense. That's why we had Dr. Volkmar. That's why the Daubert motion should have been granted, because Dr. Volkmar was the world-renowned expert in autism and says there cannot be a causal connection between ASD and HIE.
Was there a proffer that he was going to say that?
Well, we have, with the Daubert, we've got the report, affidavit, and we got the deposition, and we also proffered that we were going to offer him a testimony, and he was going to address all the issues. And with the issue about the cumulative error, Dr. Epstein, our expert, addressed the child's condition. Dr. Taylor's a PhD, can't opine on causation on ASD. Dr. Volkmar was it. The jury made a comment about the jury not hearing it, or considering that. Well, they missed the biggest witness there. Dr. Volkmar was excluded, prejudicial. Standard of care, there were 6 areas that Dr. Schifrin testified on standard of care, and the reason they got that in, and all the objections weren't sustained, they all got it in. Trial court, in those references there, said that they didn't fix it. 6 areas of the standard of care regarding prolonged labor, using two instruments that were needed. Those were standard of care, and the reason is because Dr. Hamar, their standard of care expert, couldn't do it, and they needed Dr. Schifrin to get those in to get to the causation.
Counsel, I'm sorry to shut you down, but you've used all of your time as well. I wish we had all day to argue this, but you did a very nice job arguing the case. We appreciate that. We'll take it under advisement, issue our decision in due course. Also keep an eye out on the Supreme Court of Ohio's website, which posts the opinions. Thank you again for excellent arguments on this.